very brief introduction of our speaker today, Mr. Max Barak. Max Barak leads the Garfunkel Group, I hope I pronounced correctly, litigation practice. He represents victims of workplace sexual and racial harassment, discrimination, retaliation, and unfair pay practices, such as unpaid overtime wages. He also represents whistleblowers and individuals engaged in severance negotiations. Max also actively litigates class and collective actions lawsuits on behalf of workers subject to biometric privacy violations and company-wide illegal pay practices. Max was recently again named as Super Lawyers and Rising Star list in 2020 to 2022 for employment and labor and employment litigation for the third year in a row, and Best Lawyers Ones to Watch in 2022. Max is one of the vice president of NELA Illinois for National Employment Lawyers Association Illinois chapter, co-chair of its legislative committee and communication committee, and the co-founder and co-host of the Employee to Lawyer podcast. Max is a graduate of Chicago-Kent College of Law and holds a bachelor degree with honors from the University of Michigan. Max believes that workers need a strong advocate and someone who will listen to them and fight on their behalf. Max's experience in employment law has led him to take an aggressive approach in fighting for his clients. He combines his unique knowledge of ESI with his attention to detail in advocating for his clients. He enjoys fighting on behalf of the most vulnerable workers, especially those in our most vulnerable communities. And Mr. Charles Krugo, for the past 20 years, Charles and CharlesKrugo.com has run his own management site, labor and employment law practice based in Chicago. Charles' clients are worldwide in all industries. 1/3 of his practice is HR counseling on day-to-day micro issues. Another 1/3 of his practice is transactionally based, for example, employment agreements. And the final 1/3 of his practice is litigation in both states and federal courts. Charles represents union as well as non-union companies. Charles is frequently quoted and interviewed by the media, annually gave dozens of presentations, serves on numerous boards of directors for numerous organizations, and is an award-winning attorney. Finally, he was also appointed to the faculty of Loyola University, Chicago's Quinlan School of Business, where he teaches an undergrad class in employee relations and guest lectures in other similar classes. Okay, without further ado, I will pass this on to our speakers. Gentlemen, please take it away.
Well, Sharon, first I want to thank you and these important organizations, including United Chinese Americans Illinois chapter, for having us. We're really honored to be here as part of AAPI Heritage Month to cover these really important topics, help people on both sides, so business owners and individuals who obviously are workers, navigate what's a really complicated and unfortunately at times right now very dangerous work situation, and answer questions as needed. Chuck, anything on your end before we dive in?
No, thanks for having me. I appreciate it. Glad to be here. All
right. So first, just to dive in, this is just going to be a brief overview of employment law. You know, we put our PowerPoint together and sent it to Sharon to look over, and Sharon was a little concerned at first. I'll share with everybody. She's like, man, there are like 50 slides here. There's a lot to cover. And I chuckled a little because we're just barely scratching the surface. As Chuck can tell you, because he represents companies and helps them navigate our employment laws, there is so much we could spend a whole week talking about just what employment law is and barely touch on it. So today, this is the usual lawyer disclaimer. I'm just throwing in here that this is just a little bit of what's out there. There's a lot more to be had. You can ask Chuck. Please feel free to, our contact information is going to be available at the end of the presentation. Chuck and I both are always happy to talk to folks, answer questions, and try to be of assistance. So please don't hesitate to reach out to us or another attorney with questions about these issues later. And the other thing I'll throw in here is that all of these organizations, and I think, Sharon, the PowerPoint's going to be available after for folks, right? The organizations that are listed here are just a few examples of free resources that people can get to that are government websites that give a lot of really helpful information about a lot of the topics we're going to cover today. These are going to be some of the topics we cover. We want to talk a little bit, and I think your attendees are, none of what we say at the beginning is going to be a secret about the unfortunate and really upsetting and scary rise in discrimination and violence against members of the AAPI community. We're going to talk about at-will employment because that's probably going to help people understand generally the laws that we talk about afterwards. And then we're going to talk about a lot of exceptions to that and different things people can look for, what is illegal discrimination and what they can do to protect themselves and who to go to when these things happen at work. We're also going to talk just briefly about a few other employment laws that we think a lot of folks here might need to touch on. So just to start, unfortunately, as we know, violence and discrimination against members of the AAPI community are on the rise. This doesn't just pertain to the AAPI community, but 4 in 10 Black and Asian American adults have said that people have acted as if they were uncomfortable around them since the coronavirus pandemic started. Others worry that people might be suspicious of them if they wear a mask, which is just a good public health measure at this point. And a lot of members of these communities say that they're more likely than other community members to experience racist jokes, just uncomfortable comments made to them. And close to a third of Asian adults in the United States have said they've heard that sort of thing recently since the outbreak started. More recent studies have said this has not necessarily gone away. 16% of Asian men and just 20% of Asian women feel included in their workplace. So even though we're 2 years into the pandemic, these problems have not gone away. And another study says, this one by Pew, that 3 out of 5 Asian Americans say that violence against their community is rising. And over a third have felt the need to change their daily routines just to protect themselves because they feel like if they don't, they might be exposed to violence or danger. And I've included the links to those studies. Chuck, do you want to do at will just because you're on the management side, or do you want me to run through it?
I could run through it. That's fine. It'll still get me warmed up. Just to point out one thing too, regarding statistics, the Bureau of Labor Statistics, which is part of the U.S. Department of Labor, they gather all statistics nationally concerning labor markets in the U.S. And just to give you a hard statistic as to how disparate the treatment is between different classes of people in the U.S., I think it's women, overall, all women still earn only 82 cents on the dollar for what a man earns in the U.S. And it's been like that. It's creeped up from like 80 cents like 25 years ago. So, I mean, we're slowly getting to parity, but you can see, over between that difference, just, the 18 cents, that it's a pretty still steep difference. So the idea of employment at will, and this is a doctrine in Illinois that applies, and this carries over from Old English common law, maybe even back in ancient Greece or Rome, beyond that. But it's the idea that an employer or an employee can fire an employee at any time for any reason, with or without cause and with or without notice. And vice versa, an employee can leave an employer at any time for any reason, with or without cause or notice too. And so it's the idea that we don't recognize what's called the tort of wrongful discharge in Illinois.
So that's important, and we'll cover this later, but a lot of people call me anyway to ask, well, I've been wrongfully terminated. I was fired and it wasn't fair. And what this means basically is it might not have been fair. But one of the first things I tell people is that a lot of things, unfortunately, that happen at work are really unfair, but they're not always illegal. So, a lot of people will call and say, well, my boss said I was late 3 times, but I wasn't late at all, and they fired me anyway. It's like, yeah, they can be wrong about it. It's just, they don't have to necessarily have a good reason. So just real quickly, Chuck said, just like you can be fired for no reason without notice, you can also usually quit your job without notice. There are some restrictions on that, though. There's something called restrictive covenants. So if you have a covenant not to compete, and you work in a special industry, what that can typically mean is that your employer can make it hard for you to go to somebody else in the same industry. So let's say, I guess what's a good example? Let's say you're a special kind of doctor, and you are the only person in the country other than your boss who does this kind of treatment. Let's say you're a special radiologist and you're the only person who can work a certain type of X-ray machine. And you decide you want to quit, you guys aren't getting along, and you want to set up shop down the street. Well, if you have a restrictive covenant in your employment agreement, that might be harder. So when you go to get hired by somebody or when you go to leave a job, make sure that you check for that sort of thing beforehand. And if you have signed something like that, it's usually a good idea to talk to an attorney so you understand what kind of restrictions you might be facing. Chuck, do you want to talk about nepotism and just some of the things that people see a lot that aren't necessarily illegal but are not good?
Yeah, I mean, basically the way I always say this in public presentations is that, you know, it's not illegal to suck as a manager or as an employer. So basically the idea that, you know, you can have nepotism, you can hire friends, family, not, you know, general bad, rude treatment is not necessarily illegal per se, and especially if the managers or employer is rude to everybody across the board, you know, that makes it even more less illegal, if you could say, you know, less illegal. And also bullying as a general rule is generally not illegal, although we're starting to see more states and localities make it illegal, although it's still a difficult sort of thing to define. But generally speaking, I think the abuse of power is not necessarily illegal unless it's attached to a protected class like race, gender, national origin, age, military status, et cetera, et cetera.
Yeah. So we get a lot of calls like that. When my boss was bullying me, they were yelling at me. It's like, well, do they yell at everybody? It's like, yeah, they're a really bad boss, but it's not necessarily illegal that they're doing it. So one of the things we want to touch on today is the exceptions to at-will employment. So that was the bad news. We got that out of the way. If you work somewhere, if you're a business owner, I guess it could be the good news. I guess it depends on your perspective. So there are some exceptions to at-will. One is something called a retaliatory discharge, and we're just going to touch on this briefly. But basically, if you get hurt at work, so let's say you work at a factory and some machine breaks and you're injured, or even in an office necessarily, and something breaks and you get hurt, or you suffer some kind of injury at work, it is illegal for somebody to fire you for filing what's called a workers' compensation claim. So if you get hurt on the job in a work related injury, typically you have the right to have your medical bills paid and to get your wages up to a point paid by the employer, usually an insurance company, until you're back on your feet. The thing is, sometimes companies don't like their insurance premiums to go up, so they'll fire people to try to get out of that, and that's illegal. If you see something illegal happen at work, so let's say somebody is violent, the example I always give is, let's say you work at a chemical plant, and it's like the movie Erin Brockovich, and they're pouring chemicals into the lake where the community is, and you report that to the government, or you tell your boss, I'm not going to go dump chemicals, or you say you go above your boss and you tell somebody at the top, hey, they're dumping chemicals here, or I'm not going to do it, and they fire you for that. That's whistleblowing, and that's also illegal. And what's important about that is you don't always have to be right about it. So workplace safety issues, let's say early in the pandemic, something I was seeing a lot of was people were being made to go to work in places where no one wore a mask, or they weren't social distancing, or they weren't telling people when people were testing positive for COVID, and they were getting fired when they reported it or they complained. That's illegal too. You can't be fired for reporting health and safety issues there. Chuck, anything to add on there?
One thing regarding workers' compensation, it's state law in Illinois that employers have to have workers' compensation or they have to be self-insured. However, the state certifies employers to be self-insured. So you can't just say, I'm a self-insured employer. Either you have the insurance or you've been approved by the state to be self-insured. If you don't have the insurance and you get an injury at work, I mean, that's like doubling, the exposure and liability as an employer. So if any employer ever tells you we don't have workers' compensation and I've never been required to have workers' compensation, odds are they're required to have it. Because also the list of those companies that are certified to be self-insured is published I believe it's on the Illinois Workers' Compensation website, and it's not a really long list either. So it's basically relatively few companies are qualified to be self-insured.
Does that usually mean, Chuck, that they're really big and they have I assume you just have to be really big and have a lot of money to do that?
Yeah, generally that's how it is, because my understanding is it's pretty onerous application process to get approved. So it's actually getting workers' compensation insurance is actually not that difficult for employers because there's so many companies out there. So.
Is there a reason? Do their premiums take a really big hit if somebody gets hurt? Is that why companies sometimes fire people related to that?
Yeah, I think it's for that, and because they don't, or maybe because they don't have the insurance, they don't want to be caught. So I've seen that happen too. It's a squirrely sort of argument, or a way to way to get out around the law, but I've had that happen.
I've seen that, and I've also seen it where companies have fake. So sorry, I have a 20-month-old in the background who's saying hi to her dad.
It's not harassment.
One of the things I've seen a few times is where companies don't have insurance. They'll give fake workers' comp numbers to employees who get hurt to give to the doctors at the hospital or something like that, which can cause a lot of trouble for the workers. So especially for folks who might be immigrants and don't necessarily know the system, be careful when an employer tells you they don't have that kind of an insurance. Don't help them commit fraud, because that can get you into way more trouble down the road.
Yeah.
This is just the Illinois Whistleblower Act. Sharon's going to share the PowerPoint with everybody. So just know that this is a statute that's not common law. So this is written into Illinois' laws that gives other forms of whistleblowing that are protected. So the thing that we really came here for today was how to talk about discrimination. We're going to focus on issues related to the AAPI community about discrimination, but we're going to just give you a very brief overview of what these laws are. So this is one of the other exceptions to at will. And this is what Chuck was saying earlier. It's illegal to fire somebody just because it's legal to fire them because you don't like them, but it's not legal. It is illegal to fire them if you're firing because of their race, their color of their skin, their religion, their sex. So if they're male, female, transgender, or their national origin. So if they come from another country, or even, and we're going to get to this later, even if they don't, but you think they come from another country and you fire them or you mistreat them because of it, that's illegal too. That was the federal law. So that's Title VII of the Civil Rights Act that covers these categories. In the state of Illinois, there's another statute that's even broader. It's called the Illinois Human Rights Act, and it covers way more categories of discrimination than the federal law does. So Chuck talked earlier about military status, citizenship status. You can't fire somebody because they're not a US citizen, though there are some exceptions to that. And I bet Sharon's encountered that before, where people maybe companies don't necessarily want to sponsor somebody's visa, or don't want the trouble of dealing with immigration. There are some loopholes to that citizenship status part. So there is one other law that we're going to talk about that's just like Title VII, and that's Section 1981 of the Civil Rights Act of 1991. And that says no race discrimination in contractual relationships. So that actually applies beyond just working for somebody. That's like, you can't decide not to work with a company because it's owned by, for example, a Chinese American person or somebody from the Middle East. You can't say, well, I'm not going to do business with Chinese Americans. That would be illegal under 1981, even if it's not employees that they're dealing with. And this slide is just know that this slide gives you sort of what a cause of action would be, basically when this law is broken. Couple other federal laws I'm just going to mention. So the Human Rights Act in the state of Illinois protects against age discrimination as well. Under federal law, that actually is its own law. It's called the Age Discrimination and Employment Statute. And it's not every age. So if you're 20 and you think your boss who's 60 is picking on you, that's actually not illegal. But if it goes the other way around, if you're 60 years old and your boss is some 25-year-old who's picking on you because they think you don't use the computer right, or you're not up with the lingo, that would be illegal. I apologize in the background. My daughter's just got up from her nap. Maybe people are still hearing her yell. We got a question about this, and we can get into this a little bit more at the end, but it's also illegal to discriminate against somebody because of a disability. And that can mean a lot of things. It doesn't always mean somebody needs to use a wheelchair or has a handicap sticker where they can park somewhere. Chuck, do you want to just give a brief, do you want to just touch on this one briefly, just because you're on the management side, so you're usually helping people navigate this sort of thing?
Yeah, so it's physical as well as it could be mental or psychological disability or emotional disabilities. If somebody's perceived as being disabled, that's a key thing, because if somebody says, this guy's crazy, or something, or this guy, he's taking these bizarre prescription drugs or something like that, that could lead to the perception of some sort of disability, and that would protect them. It only applies, by the way, at the federal level, it only applies to 15 or more employees, whereas at the state, and actually there's our local laws too, so Cook County and Chicago, and that applies to 1 or more employees. So yeah. Basically, though, you need, as an employee, you would need to show that you are either, there's been some sort of direct evidence, which is basically statements made regarding you that, there's a perception of you being disabled, or you have to show some sort of doctor's proof generally, or some sort of other like licensed medical health professionals proof that you have some sort of disability that prevents you from performing the essential functions of your job.
And the special thing about the ADA versus all these other federal laws is there are other things it requires an employer to do. So if you go to an employer and tell them, hey, I have a disability, I need help to do my job, and they have 15 or more employees, they may not always have to accommodate you, but they got to at least talk to you and try to help you. So if you go ahead.
Sorry. Interactive discussion, sorry. Yeah, that's the legal term for it.
Yeah, so they have to engage in what's called the interactive process. So for a lot of people in the pandemic, one of the things I saw a lot is maybe people had conditions that normally you wouldn't have to tell your boss about. So like asthma, for example. Or I had a client early in the pandemic who had something called Marfan syndrome, which I had never heard of. But apparently it's a tissue disorder, and I'm not very good at biology, or I would have been a doctor like my mom. But what I learned is that disease can make your lung collapse. And so my client only had one good lung because his lung had collapsed several times when he was a child. And if he'd gotten COVID, it would have killed him, especially early in the pandemic when we didn't know how to treat it. There wasn't, enough treatment to go around, and there were no vaccines. And he got fired because his boss didn't want to change the working conditions. He asked his boss, well, can you make it so that I don't have to come in all the time, or I can come in when no one's around and ask people to wear a mask around me and like rope off my area? And it wouldn't have cost them a ton of money. They just were stubborn and didn't want to. And he ultimately got fired. We thought it was illegal. But so when he went to them, it was their obligation to, maybe they didn't have to do everything he asked for, but they have to at least talk to him and see if they can work it out.
Yeah, and also to add that employers are required to accommodate a disabled or perceived disability when it's reasonable for an employer to do so. So, for example, if the employer would have to do major construction, that might be unreasonable. But if the employer can just has to maybe adjust work hours by 45 minutes or something like that, that might be considered to be reasonable.
I had somebody come to me one time who said they could do their job with a helper if they were accommodated. They were legally blind, but they could see. They just couldn't drive. And so we said, okay, well, what's your job that you would need a helper for? She said, well, I'm a bus driver, but if you give me a helper who can call out when I need to turn, I could do the job. And I don't mean to make light of her situation. Obviously, that was her livelihood, but you can't have somebody who legally can't see and drive be driving a bus. So not every request for an accommodation, Chuck gave an example, if it's too expensive, they don't have to do it. Or if what you're asking for is not realistic, they don't have to help a blind bus driver drive a bus. You can't drive the bus, basically. So Chuck touched on this earlier, but for the federal laws, for the most part, you need to have at least 15 people working for you. And on age discrimination, it's at least 20. And in the state of Illinois, for the Human Rights Act, it was amended about, I think it was 3 years ago, where now if you have just one person working for you, you have to follow that law. And if you're an employee and you work for one person, you're protected under state law. So don't forget that. Okay, so now we'll get to the meat of it. What do we mean by discrimination? So discrimination is a really big catch-all, and it covers a lot of categories. But in general, it means and again, there are exceptions to all of it, but basically 3 things. And Chuck, please jump in if I'm missing anything here. We have what's called disparate treatment. So let's say Sharon and I both go out for a job and I get the job because I'm a man and she doesn't because she's female, and the boss just has a problem with women. That would be discrimination. That would be disparate treatment. Or I get paid more than she does, or she gets paid more than me because she's a woman and I'm a man. Harassment, which a lot of people feel at work. And that, we're going to get into that definition, but that's not, hey, I got the job and you didn't. That's somebody's basically torturing you every day at work and just making your life miserable. And we're going to get into what that can look like. And then there's what's called retaliation. And that's where you've complained about discrimination or what you think might be discrimination or harassment, and they punish you for it in some way. And we're going to get to retaliation, but the one thing to keep in mind about that, you don't have to be right under the law. So maybe you complain and you think, hey, this is discrimination. And maybe a lawyer tells you, you know what, that probably wouldn't hold up in court, but they still fire you or they demote you or they write you up anyway. That could still be retaliation.
There's also called disparate impact, which is similar to disparate treatment. Disparate impact is an employment practice from the employer that tends to disproportionately discriminate or impact against a protected class, meaning that you have to do a statistical analysis to figure out if this practice, like a test, like an employment test, or maybe hiring only from through employee referrals that come from certain neighborhoods or something like that, has a tendency to impact against protect a minority.
Yeah, I didn't put that in today just because I've never been able to successfully bring one of those claims. They've gotten harder and harder to bring because companies usually give good even if it's not the truth, if they're sophisticated enough to give good explanations for why that's happening, they're much easier claims to beat.
The EOC tend to look out. You won't see those types of claims at the Illinois Department of Human Rights, but you may see them at a federal level by the Equal Employment Opportunity Commission. They tend to enforce that type of those types of practices, or prohibit those types of practices.
I actually had a case early in my career. I was the low level person on the case, so I wasn't making the decisions. I was at the bottom, but we represented these women in a factory in the Southeast. There's a lot of government shipyards on the Eastern Seaboard. And what they would do there, I don't think it was necessarily somebody sat there and said, we don't want any women supervisors. It's just what they did. Whenever women came to work there, it was a union shop. And for you to be a supervisor, and become in management down the road, what you had to do was get hired to one of the trades. So you had to be an electrician, a painter, a carpenter, a welder, plumber, something where it was specialized. And if you ended up in labor, you usually were never going to get anywhere. And what happened was whenever people went to work there, if you were a man, chances are you had a good shot to end up in one of the special trades as a plumber, as an electrician. And women, it was just automatically, they just sent them straight to labor. And so what would happen was that you had a bunch, women made up the majority or were close to 50-50 on who worked there, but there were like no female managers. None of them ever got there because if you didn't have a trade, you were never going to supervise one of the trade shops. So that's a good example. That's an example of what I've seen of disparate impact before. So we're going to focus on race and national origin discrimination today because like we talked about, this is AAPI Heritage Month. We want to focus on issues that are probably impacting this community, but we want to note that all the things we're saying for the most part about discrimination, harassment, retaliation apply to all these other categories. So you might be a member of the AAPI community, but you might also be female, or you might be LGBTQ, or you might be over the age of 40, or you might have a disability. So all of these other laws and the ways these laws work will still impact you beyond just your race and national origin. So, Chuck, do you want to take this one?
Yeah, disparate treatment is one of the key forms of discrimination arises, and it's basically treating somebody differently because they're a member of a protected class. The example, for being Chinese American, or because they're female. Max brought up an interesting example a minute ago regarding the labor movement, or females in labor, and a lot of labor unions have a history of discriminating against protected classes, minorities, Hispanic, Asian Americans, African Americans, and female disabled people too, and all that. So it's taken, I don't think there's parity within the labor movement in 2022, but we're inching closer and closer, very similar in that regard to the 82 cents that a female earns, for what a white male earns.
So national origin discrimination, what we're talking about is basically discrimination because somebody was born in another country, or like we talked about, they think you're born in another country. So just like maybe you were born here, but somebody's just decided, hey, I think you're born somewhere else, and they don't want to hear it. It still counts. It's not like, well, they discriminated, but you're actually born here, so they get away with it. It's called regarded as discrimination. So Title VII and then 1981 that we mentioned earlier prohibit discrimination against national origins. So you can't discriminate against people because you just don't like people of Asian American who are from, their ancestors come from an Asian country or an Arab country, just an ethnic group or people from a specific part of the world. The EEOC, so we're going to talk about where you go if this happens to you, but it's the Equal Employment Opportunity Commission. It's the branch of the federal government that investigates claims of discrimination, harassment, and retaliation. Usually, if you're going to sue somebody, you first have to go to them and give them a chance to look into it. And they're a very good organization because they give really good guides that are free, and the links to it are at the end. But you can always Google the EEOC and their guidelines on different types of discrimination and what to look for at work if you think it's happening to you, because they give really good examples of what it would look like. Their manuals are very detailed, and they're written so that non-lawyers can understand them as well. So it'll explain, what does ethnic discrimination mean? What does national origin discrimination mean? So the other things we're looking for, or discriminating against somebody because of the way they look, because of the way they talk, or what their culture does. So for example, if somebody at work thinks African Americans speak a certain way and they mock them for it, or they think Asian Americans eat a certain type of food and they mock them for that, or I'm Jewish, for example, and they don't like the type of food that my people eat and they're mocking me for that, that all counts. So things like that happen are not acceptable at work.
Increasingly hair, like hairstyles and things like that too, is becoming is a hotter topic and becoming more of a protected sort of class.
Right, it's becoming, so sometimes they're stereotyping where there are proxies for it. So maybe they're not saying out loud the thing, but they're mocking the way you do your hair. And they say, well, if you're mocking somebody's hair, it can be a proxy for race discrimination usually, right, Chuck?
Yeah. In fact, some laws now are actually explicitly including hairstyles as as being sort of protected.
Yeah,
separate sort of distinction.
So I want to talk a little bit more about harassment. I want to focus on that. I think discrimination, usually people can understand, more basically. Harassment's tough. So that harassment, and one thing to keep in mind, if somebody makes a one-off comment, it's terrible and they shouldn't do it, and you should absolutely report it and tell them if you think it's not okay what they did. But to bring a lawsuit over it, usually it needs to be more than one incident. And I'm not encouraging people to go run and sue their bosses, because sometimes things just need to be worked out and not everything is ripe for me to get involved. But Title VII, and by extension, the Human Rights Act in 1981, make it illegal to harass somebody in a way where it gets so severe or pervasive. So basically that it happens a lot, or it's really, really bad, even if it only happens sometimes. Where it alters your ability to do the job. So it basically changes your work environment for you, where what I see anyway, is people who can't sleep, or they're always tired, they get depressed, maybe they gain weight, they're losing a lot of weight, they're nauseous, they're having stomach problems, they're losing their hair. If you start to feel this way because of what's happening at work, that's the kind of thing we're looking for. It's starting to affect you, and it makes it hard for you to do your job. Sometimes it makes people's job performance slip. So what are we looking for? And this is, when Chuck and I covered bullying earlier, this is where bullying becomes illegal. So we're looking for ethnic slurs. So I'm not going to just start listing them, obviously, but slurs against somebody's race or national origin, ridiculing somebody because of the part of the world that they come from. So we talked earlier about their hair, their dress, the way they talk, what they eat, mocking people for it. I had a case once, I represented an African-American woman, And she was the only Black person who worked at this McDonald's. It was out in California. I don't remember where. And what she heard, she would randomly hear coworkers just yell out the phrase grape jelly. And she didn't know what they were talking about. I'd never heard of this before. And one day she asked her coworkers, why do you guys just say grape jelly sometimes? And one of these women started laughing at her and goes, oh, because you people, whenever you come in here, always put grape jelly on all your food.
Right.
Now, I'd never heard of this before. I've never heard of African-Americans being, like, I've never heard of that as a slur. But what she understood suddenly in that moment was that for the last 6 months, these people had basically been insulting every Black person who walked into that McDonald's and basically stereotyping them every single time. And so the joke was on her, and that was really hurtful to her. So sometimes it's not obvious. It's not as simple as, oh, you're from this place, well, you're a this or you're a that. It's something less obvious that people are doing to mock you to your face. You may not even always realize it. Workplace graffiti can happen if there are Jewish Americans working somewhere and somebody puts a swastika on the wall or draws a noose or puts a rope on somebody's desk if they're Black. We've seen that before. Really anything racist or just offensive you can think of that ties to somebody's skin color, where they come from, how they talk, what they eat, how they sound, anything like that is going to count. And if it happens a lot, it's going to be a problem for the company. So here's one.
I sort of asked this as a rhetorical question, but because I've seen this come up a lot with managers, supervisors, companies, is referring to a group of people as you people, or people like you, or people like them.
I've got a couple of those right now where employees were said, you people need to get your people,
yeah,
this or that. And it happens a lot like that. I represented a Chinese American woman a couple years ago, earlier in the pandemic. She worked at a hotel, and there was this boss who I'm very glad they eventually fired, not just because I think he was a bad guy, but I think it was really bad for their business. And this guy should never have been running the hotel, because he got into it with any person who wasn't a white man. He couldn't interact with anybody. And our client was a Chinese American woman, and the guy used to mock her constantly for being good at math. And when she said, I'm going to make up his name, Johnny, I think that's really offensive. Can you please stop doing that? She wasn't looking to run and sue somebody. She didn't want to lose her job. She didn't want to make a big deal of it. But the guy kept telling her, well, it's a compliment. You shouldn't be complaining. Like, that's a good thing. Well, it's not for him to say that it's a good thing. It was offending her. She said, please don't make that joke to me anymore. He didn't seem to understand why that might be a problem. So we certainly see a lot of that, sadly, a lot.
What about the Jewish lawyer?
Yeah. Well, you had that happen to you one time, didn't you?
Yeah, I think actually more than once, I think. So, and it's kind of a weird sort of, it's very awkward.
Yeah, I had that once. I had a case out in Las Vegas, and somebody filed a brief on the other side. I worked for a New York firm at the time, and he said these New York lawyers with their New York style litigation tactics, which I thought he meant these Jew lawyers coming in with their Jew lawyer tactics. That was the way I interpreted it. We didn't make an issue of it, but I thought it was pretty offensive. So one other thing to keep in mind about harassment is it's usually, and there are some exceptions based on who harasses you, usually it's not enough to bring under law, it's not enough that it happened. So there are a lot of factors that go into it. Is it just a couple of comments? So there are courts that even say, was it one or two jokes here or there, or was this constant? Was it benign, or was it really, really bad? How often did it happen? Did the employer know about it? Did it affect you? All of these things go into it. So Chuck, I think we were going to cover this a little earlier. I think this is sort of your thing. What's not harassment?
Well, obviously the 4 things are listed there, but basically it's unprofessional, being unprofessional, or being a poor if you're in a leadership position at a company, being a poor leader or manager, that's not illegal. That's generally not harassment. The abusiveness to all part, that could go either way sometimes, because if the abusiveness is attached, obviously, to some sort of classification like race, ethnicity, religion, that could rise to the level of illegal harassment. But generally speaking, abusive, it's all just being a poor manager or an abusive manager to everybody without regard to the protected class. That's not illegal. And actually, I have a client of mine who's like that. So the guy, the managing partner of this company is, kind of yells at everybody equally. So,
yeah, and I saw somebody put in the chat that gaslighting and microaggression are rising, and I see a lot of that too, and that's really hard to quantify because microaggressions, right? Like they're not always as obvious, but over time it starts to really wear somebody down. That can be really hard to quantify in a harassment context, but it certainly happens a lot.
By the way, the whole gaslighting thing, I mean, it's not a defense for a company to say, oh, we're just joking around, or, oh, you're just blowing it out of proportion. That's not a legitimate defense to that type of conduct. So, yeah.
Right. It's not. So who the harasser is matters. So if your coworker, listen, if you work at let's call it, I always use the factory example just because it's easy, but let's say you do work at a factory or you work in an accounting firm, wherever you work, and your coworker, the person who sits at the desk next to you, is making these comments to you every day. If you don't tell them or you don't tell the company that it's happening and that it's not okay, and they don't know about it, usually, unless it's so obvious that it happens in front of them every single day and they just don't do anything, the employer is not going to be liable for it. So if they don't know what's happening, it's hard for them to fix it. And the law usually protects companies against that. So wherever you work, one of the things you need to do is look for what their policy is as to how you report this sort of thing, who you go to. And you need to make sure you follow that whenever you can, and you make a note of what's happening. And it's not enough to tell them that they're rude to me or they're not being very nice. You need to usually spell out exactly what's happening. And it's a good idea to, verbal complaints do count, but it's a good idea to put it in writing and to be very specific about what's happening, just so that there's a documentation of what's happened.
Yeah, it's a cliche, but if you see something, say something.
Yeah.
And the sooner you say something, the better off you'll be. And, it's not ratting out or tattling, it's basically, it's the bureaucracy. I mean, we're an increasingly bureaucratized society, and this is part of the bureaucracy, is to document. And the documentation part, be simple about it. I always say stick to the W's, like who was involved, who witnessed it, where it happened, when it happened, what was said or how it was said, that type of stuff. Almost like writing an elementary school book report.
Right, because sometimes people write these really nasty letters to their bosses about what's happening, and it's like, well, you should tell your boss what's happening, but just laying into everybody and starting to yell at them and be rude in it is not happening. Stick to the facts, tell them what happened, and explain what it does to you. One other thing I see a lot is people quit as soon as these things happen, or if it happens enough and nobody fixes it, maybe because they didn't know, they quit. And that usually is not, if you come to me after that's happened, or if somebody comes to me, usually it's hard for me to help with that because the company may not have even known it was going on. And maybe, I mean, listen, some companies are really bad and they're not, but a lot of them, especially folks who've got someone like Chuck looking after them, are usually going to be pretty good about trying to look into what's happening and fixing it, and trying to protect you. So if they don't know, there's not much they can do about it. And your lawyer won't be able to do much for you either.
Also, if you quit,
yeah,
I would say about 75% of the time you render yourself ineligible for unemployment compensation benefits. Right. So if getting unemployment matters to you, don't quit.
Right. I'm going to briefly mention retaliation one more time. Just that if this is happening to you at work and you do go to your boss and you report what's happening, or you go to human resources if it's a big enough company where they have it, or you object, or you say, this isn't okay, I don't want you to do this anymore, this is really not all right, and you get punished for it somehow. So you're fired, you're written up, you're disciplined, your pay is cut, you're suspended, something to discourage you from doing it in the future, that's also illegal. They can't punish you for reporting it. Now, there are exceptions to everything. I've had clients who were serial complainers about everything that happens ever. And that makes it harder for the company to know what's really going on, because if you complain every time somebody pushes a stapler onto your desk, they may not take it as seriously. But bottom line, if this happens and you're punished for it, that's also illegal, and that would violate all of these laws as well. I think we still have a fair amount to cover, so I don't want to go through all of the elements of the retaliation claim, but the thing to keep in mind basically is if you oppose discrimination, you report it, something bad happens to you beyond just, hey, drop it. And your lawyer can tie those things together. That usually constitutes what we would call for actionable retaliation. So what are we looking for so this is to tie it all back together. So what do you look for at work if you don't know if this is happening to you? Well, if you, just by virtue of being in your community, are being picked on, you're not being given the same opportunities for pay, promotion, discipline, whatever, people who complain get punished for it. I have a case right now where a woman said, hey, I think I'm being paid less than this guy. I've been here longer. I have more years experience. And the boss literally said, I can't believe you accused me of that. I don't want somebody around here who's saying discrimination to me. You're fired. You're smiling, Chuck. I can't.
Yeah, it happens a lot. I see that happen a lot.
It's crazy. You think it doesn't, but it happens a lot. And
by the way, it's not that difficult to prove either, because once you look at the people's background and what they're earning and all that, I mean, once you compare it all, it's usually pretty obvious whether or not it's occurring.
Yeah. And on that note, a lot of companies try to have a policy where you're not allowed to talk about what you earn. And they try to protect themselves by saying you're not allowed to talk salary with other people. That too is illegal. You do have the right to discuss your money. It doesn't mean you should go start putting up flyers all over the office. That's a little different. But like, bottom line, if you get punished for talking who earns what with your coworkers, that would also be a problem.
That's protected under the National Labor Relations Act, oddly enough. So anytime one or more employees is talking about wages, hours, or conditions of employment, or issues that are of a general concern to all, more than one employee, that's protected activity.
These things. Okay. So this is the important takeaways here. So what do you do if this is happening to you? Well, some of this we've talked about. Chuck was good to explain, you need to tell them when it happens, report it. We've mentioned the EEOC for a while at the state level. So for the Illinois Human Rights Act, if you're one way or the other, if you think you're being discriminated against, you can go to the state or federal government. You have both options. And depending on what county or city you live in, if you live in Chicago or you live in Cook County, you might have a county organization. There are groups that exist through the government that look into this sort of thing. So you can go and file what's called a charge of discrimination with the Department of Human Rights or the EEOC. You can, and they will investigate it. A warning, the IDHR usually takes on average about 6 months to pick up a file. And the EEOC is usually better, although for the last 6 months, they changed their computer system over. So they've been a little slower than usual. I don't know what your experience has been, Chuck, but I've got a bunch of charges that are just sitting there.
Yeah, I've had the EEOC generally takes at least a year, and the Illinois Department of Human Rights, my experience is about 2 years. The Illinois Department of Labor, at least 2 years. The Cook County Human Relations Commission, they're empowered to handle employment, but I've never actually heard of an employment case being handled by them. So I'm not sure that they're such a good agency to go to. But the Chicago Commission on Human Relations, I think that's the name of it, they've handled some employment matters. And my understanding is that they've recovered money on behalf of employees or ex-employees. So
the EEOC usually does a pretty good investigation when they do. They just don't always investigate. Sometimes they get really busy and they just say, we don't have time. Early in the pandemic, one thing I was seeing a lot of was people were filing a charge and they were getting a right to sue letter like within 2 or 3 weeks. Like the EEOC just didn't have time to investigate anything. So they were just issuing these letters, which was hurting people because then it was harder for lawyers to get involved. Because once that letter goes out, you only have 90 days to file a lawsuit. And you can always call an attorney. Some lawyers do charge for consults, some do not, but if you think it's happening to you, it's usually not a bad idea to talk to somebody about it. The worst that happens is you get more information and you find out it's just a bad place to work. Maybe it's not illegal. You never know.
By the way, if you do call an attorney on a matter like this, call somebody who's got experience or focus, at least in this area of law, because I've had people come to me, and sometimes employees will call me and I'll talk with them. because I hate to see them go out and maybe get ripped off, and they'll tell me like their attorney said X, and then I'm like, well, no, it's Y. And, you know, and honestly, I think 75% of the time I disagree with an attorney, I'm right. So yeah, it's just, I can't, just don't go with a lay person or a lawyer who doesn't really, you know, handle this type of matters.
On both sides. I mean, I've seen it too, like on the other side where you've seen it with workers because you present companies. I see it the other way where I'm up against companies who've got like their divorce lawyer doing the case or their real estate lawyer, and it doesn't help them. They're worse off for it. That lawyer usually gets them into trouble. So whether you're a business owner or an individual who's going through this sort of thing, and you do go to a lawyer, make sure it's somebody who knows labor and employment work, or you're probably not going to be better for it. One thing to keep in mind, there are some exceptions to this, like anything else. But if you think this is happening to you, you can't run straight to court. You got to go to the EEOC or IDHR first and file a charge before you can file a lawsuit.
We have a question, actually. I'll read this. What suggestions do you have in terms of collecting evidence? The discrimination is oftentimes subtle / verbal, and the other party can just say it's miscommunication, misunderstanding. Should I go ahead or?
Why don't we, well, I think we wanted to cover them all at the end,
Okay.
right? So I think we can get all of these. A lot of them are overlaps on some of the ones we've gotten before. We'll get to it.
Okay.
So a couple other things. Your employer has to do annual sexual harassment training. That's a new law in Illinois that took effect on January 1st of 2020. If they don't, they can get fined. Chuck, it's like $500 a year, right?
Yeah, that's right.
Yeah, but the other thing is if they don't do it and then harassment happens at work, it's really strong evidence that they don't care about that.
Yeah.
And can be bad.
Or if you have a policy and you don't follow it.
Right. If this is happening to you as an employer and it's happening at your workplace, more training is good. Obviously, investigating and dealing with it. If you're a worker, document. You want people to know if it's happening and to be able to fix it. Communicate. I think, you know, at this point, we're repeating some of this stuff.
There's two types of evidence generally that's looked at. One is direct evidence, which is basically, you know, you call the person's call a name, or it's in writing, or the graffiti, that type of stuff. And then there's indirect evidence, which is more subtle. That could be more like the disparate impact, like practices that tend to disproportionately discriminate against a protected class, or not getting a promotion, not getting, you know, raises, or, you know, things like that. So direct and indirect evidence.
Or
and
the
indirect.
I'm sorry. No, go ahead.
Yeah, the indirect is a little bit tougher to prove for the most part, but I also think that's the more prevalent type than the direct evidence, because most people, you know, most of the time you're not going to see direct, you know, you're just not going to see an employer hand you the evidence on a silver platter like that.
Yeah. Other examples are like maybe the excuse that's given for why something happens isn't true. They say, oh, well, your job performance wasn't very good, but you've gotten all good reviews until something happened. That's evidence that what they're saying is not the reason.
Yeah, that could be pretextual evidence or circumstantial evidence of it. Yeah.
Yeah. So I know we're a little short on time. We have a little bit more to cover. We should be okay. There was a question about evidence, and we'll get to that. One thing not to do, for all that is good and holy in this world, do not secretly record anybody. I know it can be frustrating that it feels like HR doesn't believe you and you think it's the only way you're going to be able to prove it. It is one of the most common things I see, and it is incredibly illegal. It's a felony under state and I think federal law as well. And you're not even allowed to, usually there are some exceptions, but the general rule is you can't even use that evidence if you get it illegally that way. So, and I say that without any judgment. People don't always realize that it's illegal. It's a good, you know, people's impulses. Well, this is the only way I'm going to get them. You can record them if they know it's coming, but if it's a secret, you got your phone on your desk or something, you can get yourself into a lot of trouble that way. So be very careful about that. One other thing, just don't get into fights with the coworkers. Sometimes you can't help it. Maybe you feel like they're pushing you, you just snap, something happens, but try to keep your cool, because usually if it's a workplace that tolerates this sort of thing, they may end up punishing you for whatever happens. Couple things to keep in mind: statutes of limitations under these laws. It's usually 300 days from whatever has happened to you. So if it's harassment, there's something called a continuing violation. Like if it's ongoing, it's sort of the 300 days runs from the last incident. Chuck, correct me if you have a different understanding of that, but that's always
and that's the same with also pay issues too, because you go by the last, the last incorrect pay or the last time you were discriminated on the basis of pay. So,
yeah. And for 1981 claims, usually it's 4 years. I'm going to briefly mention hate crimes because we've seen a lot of it, sadly. That actually, so in addition to being illegal and bringing you criminal charges if you do that to somebody or if somebody does it to you, and that's defined as somebody basically committing an act of violence against you because of who you are, is the simplest way to say it. If you're a member of the AAPI community, you're Chinese American, anybody else within that group, and somebody's violent with you because of who you are. And very, very sadly, we've seen a lot of this during the COVID pandemic because certain people have demonized certain groups to justify not fixing the pandemic, basically, right? Like that has caused a lot of violence and harm in certain communities. That's illegal. It's not just a crime, however, because if it happens to you at work, you can actually sue that person for it. We have a case right now against a municipality where someone who's LGBTQ was beaten by a coworker who's, I don't know how else to say it. He's like a neo-Nazi. So we've brought discrimination claims against that employer, but also hate crime claims because this kid was beaten up for being gay, basically. If that happens to you, you should absolutely report it to law enforcement, but also you need to document it with your employer, and take pictures, like document what's been done to you, because you're going to need that evidence down the road if you do bring a lawsuit, especially if your employer allowed that to happen. Now that's complicated, but very, very briefly, just a couple other laws you want to keep in mind. Even if you don't have a written contract with your employer, you have a right to be paid what's been promised to you. So my favorite law that nobody knows exists is the Illinois Wage Payment and Collection Act. If you Google it, it'll take you to the Illinois Department of Labor's website on the language in that law, and it'll give you some regulations, but they can't stiff you on your final paycheck. You have to pay out accrued paid time off. You have to pay out earned commissions, guaranteed bonuses, and Chuck, anything else, and expense reimbursements, right?
Yeah, expenses. On the paid time off, it's generally vacation time.
Yeah.
But if an employer lumps all paid time off into the same sort of bucket, then you have to pay that out, the accrued paid time off.
And there are also really strict rules about deducting from employee pay. So if you have to pay for your uniform or they fine you for something at work, you should check this law or talk to an attorney about it, because the way it's done has to be very specific.
Yeah, wage garnishments, that type of stuff too. Yeah, there's a sort of a limit to the percentage that can be deducted per paycheck.
And it's got to be agreed. There's got to be like an interactive process about it usually. If it's
and they have to notify you ahead of time in writing too.
A couple other quick things. If you are an hourly worker, you have a right to be paid at least the minimum wage for all hours up to 40, and time and 1/2 your hourly rate for all hours after that. There are a lot of exceptions to that, but that's the general rule. The statutes of limitations on these for the Wage Payment and Collection Act, it's actually 10 years long. So if people have had a lot of money stolen by a boss and they think, damn, 2 or 3 years have passed, I'm screwed. You're actually not. You've got a decade to go back. And for overtime and minimum wage laws, however, it's usually 2 or 3 years. As Chuck and I know, sometimes there are some exceptions to that too, but that's the exception to the rule.
By the way, here's something really bizarre about the Wage Payment and Collection Act's 10-year limitations. It's not actually in the statute itself. It's a separate statute. Yeah, it's a separate statute. So it's just very bizarre.
I had a lawyer bring that up, and I had to find where it was at one point because they filed a motion to dismiss on it.
Yeah.
So we covered most of this. Couple other things. If your workplace is unsafe, if they're not telling you people are getting COVID and getting sick, they shouldn't tell you who has COVID necessarily, but they should be telling you that somebody close to you has been exposed and that you might want to get tested. If there are other safety issues there, you can report it anonymously to the Occupational Safety and Health Administration, OSHA. It's a very streamlined process. Employers really don't like being investigated by OSHA, right, Chuck?
Yeah, and also employers are required to make reports out to OSHA, and I've seen a lot of cases where the reports either aren't done or aren't properly filled out or reported. So.
And they can get fined for that too. And they're not allowed to punish you for going to OSHA. You can do it anonymously or you cannot. Last couple ones, there's something called the Illinois Gender Violence Act. If somebody, usually it's sexual violence, like a sexual assault, but because survivors of assault often are not ready to talk about it right away, there is a 7-year statute of limitations on these claims. It's not all sexual harassment. There's got to be an unwanted touching of some kind. If you work for an employer who gives you health insurance, and they're over 20 employees, they need to give, well, either way, they need to tell you if you have a right to COBRA. If you get fired or you lose your job, you have a right to continue to pay for the insurance. If they don't tell you, you can end up suing them for that, depending on how it happens. And if you clock in at work using a biometric time clock, you use your thumbprints usually, or fingerprints, or palm prints, or even retinal scans, that's legal. But there are rules about how it's done, and they have to tell you in writing that it's being done. They have to have a policy in place about how they handle that data to protect your information. And they got to tell you if they're selling or they're giving it to another party. So final takeaways. Chuck, do you want to give the final takeaways for the employers?
Yeah, for the employers, follow the golden rule, document. And, you know, I always use these 2 words, but maturity and leadership. I mean, if you're an employer, maturity and leadership are key things. So, you know, act like an effective leader, an effective, mature leader, and investigate too. I mean, if you're going to, you know, you document and investigate, you know, if you're going to talk the talk, then at least walk the walk too.
Yeah, I mean, I always say I'm kind of like a criminal defense lawyer. If the police do their job right, there's nothing I can do. So if you have a lawyer like Chuck representing you who keeps you out of trouble and make sure you take things seriously, there's not much I can do to help a worker usually, because usually the company's done it right. So, and on the other side, you know, try to know your rights. There are supposed to be notices put up. If you think it's happening to you, you should say something, be specific, and document it.
And that was one of the questions, you know, regarding documentation, you know, gathering evidence. That's typically the most prevalent form of evidence is documentation. So it's the idea of you writing down what occurred, when it occurred, how it occurred, who witnessed it, and then trying to get statements from those other witnesses or photos or things like that. Or maybe even telling your employer, if you know that they have recordings in the workplace, not to destroy them and save those recordings.
So I think we've pretty much covered everything we wanted to. Sharon, do you want to handle the questions?
Yeah, so thank you so much. This is such a deep, like, you know, labor and employment law in an hour, really. But we're barely scratching, like you said, we're barely scratching the surface, really. And I wanted to remind it's, you know, because the legal system in the United States is not only federal, also state, and sometimes county as well. So it's extremely complicated. But, you know, to our community, because of the culture difference, I have to reiterate again, we don't think a lot of problem, you know, sometimes we don't think I want to report it. You know, I don't want it to raise my voice. I don't want it to, you know, somehow retaliate it or target it, you know. So if you feel something is wrong, you know, there might be something wrong. Okay, so let's go into the questions that we previously received. The first one is how to deal with different, some of them are general, so maybe we just give some general tips. Some of them are hypothetical, so we can dive deeper into that. So the first one is how to deal with difficult manager who is trying to make you invisible.
That's a tough one. Chuck, do you have an HR perspective on that one?
Yeah, it's basically, I think you have to talk with the manager one-on-one, because unless this invisibility is attached to you being in a protected class, and you know that, you know, you have some direct evidence or some you got some good circumstantial evidence, basically then you're left to your own devices to basically talk with them one-on-one and call these issues to your attention, or to go, you know, to a third part within the company, like an HR person, or maybe the supervisor or something like that. It's a softer sort of issue. You know, it's like, Matt's just said, it's more of an HR management issue, probably than maybe a legal issue. So it's just a matter of calling it to their attention. Again, if you see something, say something. And I think the sooner you say something and call it to their attention, the better off, generally speaking, the better off you'll be. There are times where calling it to somebody's attention could backfire, but that's just a chance you may have to take. Otherwise, you just sit there and let it fester.
Yeah.
And just to broaden it a little bit. For example, if my manager I don't want to say we're against Indians, but pick the Indian manager who is on the same level and we have the same background or same qualification credentials, because the manager is an Indian.
Yeah. By the way, the invisibility thing is interesting because I personally experienced that myself, and actually it was a good thing for me because I came to realize that my boss only messed with people that she thought were really bad employees, and she left the good employees alone. So, sometimes it could be a blessing in disguise if you, depending on how you perceive it or how the boss actually perceives you.
Yeah. Was there another question there, Sharon? I'm sorry.
Yeah, so just broaden it a little bit. So what if, my colleague, we are all managers, my Indian colleagues are also manager, but my boss is Indian, so he picked him.
That's really hard. It could be discrimination. I mean, if you think it is, and you want to continue to work there, what's hard about these cases is it's important to bring this stuff up and get it fixed. And at the same time, sometimes people are just not willing to hear it. So if you do think you were not promoted, I mean, there are a lot of things that go into it. Have they made comments about non-Indian workers? Are they favoring only Indian employees alone and not others? Those things do factor into it. If you think it's happening, I think we're going to sound like a broken record, but you can document, if there are objective criteria. So if they're saying, hey, this promotion is based on how much you produce, how good your job, your job performance is, and how long you've been here longer, you produce more and your performance is better, and the other guy still got the job, then it might be discrimination. And you might consider reporting it internally or going and filing a charge about it. Just make sure whatever you do, you understand that you've documented it and you've prepared yourself, because, you hope the company would take it well, but they don't always. And sometimes, it's like Chuck said, you may be in a it might be not a win-win situation. It might be either you stay there and you continue to get mistreated, or you report it and you still end up having to leave ultimately. So it can still be a challenge.
Okay, we do have a lot of questions, so we have to go this very briefly then. So there's another question about, is there any discrimination against the mental health state?
Yes, that's the ADA and the Human Rights Act. So if you have mental health difficulties and you've reported them and you've asked for an accommodation, maybe you have bipolar disorder and you need time to take your medication, or maybe you suffer from depression and you need to be able to leave the office early on a Wednesday to go to therapy, and they're not giving it to you, that would be a failure to accommodate. If they're punishing you because of these issues, that can also be an issue. Mental health is tough, however, because sometimes you're having these issues and the company doesn't know and it's making it worse. So once again, if they don't know what's going on, it's hard for them to fix it, and you're not necessarily protected.
And by the way, the company does have the right to ask for proof, some sort of proof or certification from a health professional doctor regarding the condition and how that condition prevents you from performing essential job functions.
But they have to keep that information confidential. So they shouldn't be running around you shouldn't be afraid to tell them, because they have an obligation to keep it confidential and not tell everybody.
And can't run around saying Chuck's a schizo, stay away from him.
Exactly.
Next one is, what contents, if you do hire a lawyer, what do you communicate with a lawyer, generally speaking?
Well, you should tell them the truth. You should try to focus on, a lot of people have a lot of grievances that are very real and fair to have, but they're not always relevant to the case. So a lot of people are kind of obsessed about maybe microaggression incidents or incidents that don't necessarily touch on what you're bringing the lawyer on, and they really get focused on that. What you need to focus on is sort of the big picture. I think I'm being discriminated against because I'm an Asian American, because I'm over 40, because this happened, that happened. And you want to try to stick to the facts and the things that you think are tied to that. So what is it that's happening that makes you think it's discrimination? And how is that related to that special category about you?
My experience, way more than half the time, either the employee or the employer doesn't tell you everything that you need to know for a case. And that comes up so often where something I find out later on, maybe even short of just, a trial or something like that, I should have known ahead of time. And they were, the person was afraid to tell me that because they thought maybe they would get audited by the IRS or something like that. Most recently, I'm dealing with this case right now. I have a client who, they had a union, there's in the background of a discharge was a union issue. And they said, well, the union issue doesn't have anything to do with this person being fired. Actually it did. And it provides us a legitimate defense because the person's claiming they were fired for filing a workers' comp claim, yet they were actually fired and documented. It shows because they went on strike, an authorized strike during a union drive.
So just tell the truth, basically.
Yeah, tell the truth and tell everything.
Yeah.
Another thing is that clients and attorneys have attorney-client privilege. So anything that is communicated with client with the lawyer is confidential.
Except if you tell us you're about to go commit a crime, then we might have to tell somebody. Right. Don't tell us you're going to go kill somebody. But anything you tell us is secret. We have to keep it between us. So don't be afraid to tell us stuff because we can handle bad news. We can't handle surprises.
Right. So the next one is, I guess, generally, what is the best way to deal with discrimination at work?
So I think we talked about this. You want to document it. You need to tell somebody that what is happening is not working with you, that it's upsetting you, it's hurting you, and you need to be specific. Sometimes I had an old professor tell me when employees get a lawyer or they think they're being discriminated against, they use it as an excuse to get really nasty with people and just send these horrendous letters to their coworkers. And you really don't want to do that. So what my partner likes to say is, let's just stick to the facts, ma'am. Just be specific. I think, Chuck, you said there were a bunch of W's you like to refer to.
Yeah, what, when, who, where, why, how. Mm-hmm. Also, when you document something or you get statements from people, and you're investigating, do it contemporaneously or as soon as possible after the incident occurs. Because if you document like a year later, your credibility is going to be called into question.
Right.
Okay. So I guess this is not a legal question, but in case you can pick up anything legal here. So how to ask for salary increase? How to get manager to support me to reclassify my job level?
Chuck, do you want to take this one?
Yeah. So asking for salary increase is that's a really difficult one for a lot of people. And basically, it's just, I think you just have to come out. It's like, yanking a Band-Aid off. You just got to do it and do it in a nice way, obviously congenial way, because people don't like to work with jerks. So, if you come across as a jerk to your employer, you probably won't get the result you're looking for. So basically gather some data, how much other employees are making. Remember, it's not illegal for employees to discuss compensation amongst one another. So, find out what other employees are making, find out maybe if there's a difference in gender, if there's a gender disparity, find out how much other people in your field for other employers, especially other employers in similar geographical areas, pay their employees. So look at, try to do some sort of data analysis as much as you can. Like I said earlier, the U.S. Department of Labor gathers a lot of statistics on that, and they're really good. Their website's actually excellent, so they're a really good resource for this type of stuff. And then, I'm sorry, what was the second part of that question?
How to get reclassified in your job level, and maybe a promotion, I think, is what that might be alluding to.
Yeah, it could be the same way, basically showing the employer why reclassification is justified or why it might be the legal thing to do, because generally classification is a legal sort of term. So
yeah, and the other thing too, Sharon, you said sometimes culturally people don't want to make waves or they don't want to make trouble. I think the thing to keep in mind too is if you don't ask, the employer may think you're happy with what you're earning or what your job title is, and they won't know that you think you need to be moved up. And there's a phrase, it's like, what is it? The squeaky wheel gets the oil.
Yeah, the squeaky wheel gets the grease. Yeah.
Yeah. You know, if you don't make noise, I'm not saying, it's like Chuck said, you don't want to be a jerk. You don't want to go running around screaming, I don't get paid enough every day. But if people don't know you're frustrated, they may not realize there's a problem.
You know, I always say this to clients, that constant complainers are basically, you know, saying to you that my career options or my career ladder in this company is limited. It's a leadership thing. I mean, if you want to be put in a leadership position, behave like an effective leader would, and basically bring these complaints or issues to your employer in that manner, in that context. You know, here's why I think I deserve this. You know, I looked at these factors, I looked at these criteria. I know that maybe other employees are making this. And sometimes if you say to an employer, I know that other employees are making this or doing this, that might, you know, tip off to the employer that this is this contentious person, but you could do it in the right way. I mean, there is a right way to do it.
And I guess the next question that we touched on this a little bit about unfair promotion in workplace as well.
Yeah, I think we talked about this earlier, but if it is only going to people of a certain group, you may be working somewhere that does discriminate. You may not. I mean, it's always hard to know. But if you think it's happening and you can point to, you know, the data that I think the example Sharon gave earlier, that, you know, the boss is Indian American and they only seem to promote Indian or Indian origin employees, then yeah, maybe it is happening there. You need to document, and you might consider reporting it to the employer or filing a charge and talking to an attorney. It really depends on the scenario.
By the way, and you know, coming up with the evidence, sometimes you may only have a scant amount of evidence in terms of quantity or quality, but during the investigation process or in the litigation, what's called the discovery process, more evidence might come out.
Yeah. You know, the things you're looking for are basically what Chuck was referring to earlier, objective criteria. That I've worked here 10 years. I've seen 5 people go up for this promotion. Every single person who's gotten it has been somebody other than me. I've been here longer than all of them. My ratings are higher. I earn less. Those are the things you're looking for. Don't think that because you don't have somebody on tape saying I'm not promoting you because of where you're born, that a lawyer can't help you. You would be surprised. So just focus on the specifics. That stuff may carry you further than you think.
Okay, so the next one is, I guess, you know, how likely our workplace take this issue seriously? I think it has something to do with our culture differences, really, you know, because a lot of times we were taught to submit to authority. So we don't want to make trouble. We wanted to look nice and kind and, you know, be the quiet worker that is make best contribution to the company. So I guess give us some confidence how we workers are treated, are favored in court.
So, you know, it's interesting from my perspective, discrimination cases, this is actually, companies care more about it than you think. They really don't want to be the company that's known for discriminating against people. They really, really don't want to be that. And if they don't know they're being perceived that way, they may not realize they have a problem. But the other thing to keep in mind is you don't have to prove, you know, when you go to criminal court, the government has to prove by what's called beyond a reasonable doubt, which basically means there can be no doubt that you're guilty of something. But in civil court, it's a much lower standard. It's what's called a preponderance of the evidence. So it's basically just more likely than not that there was discrimination. And the test, Chuck talked about direct versus indirect evidence earlier, and that is a thing. But the test is a lot simpler than it used to be. There was a court decision about 5 years ago called Ortiz. All you need to know about it is that the court looks at all the evidence, all the factors, all the circumstances, and says, knowing everything that we know, is it more likely than not that somebody was discriminated against here because, for example, they're a Chinese American? And if the answer is like 50.1% yes, then they're responsible and you've won. Now, it's a long way to get there. These cases are really hard, but if you think it's happening to you and you can tell your lawyer or the EEOC or the IDHR, look, I've been here 20 years, I've been here 5 years, I've been here 10 years. I've heard my boss say this about Asian Americans for months, for years, whatever. I've gone up for 10 promotions and 10 different people younger than me who were white or some other group have gotten it. There's a good chance your lawyer may be able to help you, but if you don't go to them and tell them, they won't know, and no one will ever be able to help. So it's hard, especially when you've been taught to be a certain way. Just know that there are a lot of lawyers like myself out here who do this, who believe what you're telling us. And one thing I tell clients is, you know yourself and you know your workplace better than me. And that feeling you get in your stomach when you know somebody's looking at you differently, it's there for a reason, because you've lived in your skin your whole life. You know when someone's looking at you differently. Don't be afraid to go to a lawyer and tell them that, because we might be able to help you. You never know.
Great. So the next one is, now we are working from home permanently. My manager always call me after hours. Is this legal?
Chuck, I think this is something you've covered. I've heard you talk about this before.
Yeah, so basically, if you're an hourly employee or being paid hourly, yeah, it could be illegal. If you're a salaried employee, it may not. As a general rule, it's generally not illegal. Although, if, you know, this would be maybe a bizarre example, but if they're only calling female employees after hours, yeah, that could be illegal. You know, setting unreasonable expectations. So that's
what
like
if the call is really a lot of calls, like mounting to about like 5 hours after hours, and they're not getting after hour pay?
Well,
they're getting after hour.
They're not.
Well, if they're hourly employee, that's definitely illegal. If they're salaried employee, that still may not be illegal.
Yeah.
So is there any reasonable bar that you can cross that this is legal, this is not, for a salary?
Well, what is it? What's the salary threshold now? Is it 57 or like 58,000? Is that what it is?
And it's like 684. I think it's 684 a week, right? Is it?
Yeah, yeah, 684 is something like, but it's like, yeah. So if you don't meet the salary threat, if the employer is paying you less than the threshold to be a salaried employee, then yeah, that could be that could violate the law. So I think it's like 58 a year.
Yeah, I honestly, and this might feel like a cop-out answer, and I don't mean it to be, it may just be a really toxic place to work. Like, you do have white collar jobs where it's not an hourly pay situation, where you have a boss who just has ridiculous asks of you and demands you to be on the clock till 10 o'clock at night every night. It may just be a really bad place to work. It may not be illegal necessarily. It may just be a bad place to work.
Okay, so the next one is, I was paid a minimum severance fee after 15 years working with the company when the company was bought by another bigger company. Is this legal? I guess he means minimum about like 1,000 or something.
Yeah, and that can be really unfair unless you have a contract that guarantees you a certain type of severance. The only way I can think of that might be illegal would be if they were giving people of a different group more money than you. So if you've been there 20 years and they said, hey, anybody who's been here, we give them a month for every year they've been here, except for you, because maybe they didn't like Asian American folks, or you're of a certain age, something like that, then it would be illegal. Otherwise,
but how would they know? Because the other employees are not talking.
That would be really hard. If they're not telling you, then you may have a tough situation. It may just be a really poor way to treat people. Sadly, one of the things I have to tell many people who call me is not that nothing I can do, but a lot of things that happen are really just not the right way to treat people, but it doesn't always make it illegal. It might just be they really mistreated you there.
It's tough telling somebody to look for another job.
Yeah.
Is there a common law here in Illinois where you work for the company for over, like 15 years, a really long time, that you have like, even though that you don't have an employment contract, but somehow you have a virtual like de facto employment contract?
No, unless there's statements made contrary. Yeah.
Well, kind of. It really depends. It can depend. So that Wage Payment and Collection Act, the only exception I can think of to what Chuck is saying is if they have a practice where we give severance of a certain thing to people, anybody here who we have to lay off because the company gets bought or something happens, we have a standard practice of doing this, and they just, even if it's not in writing, but it's what they do, that would be one thing. Where it changes is there's nothing in right. You don't have a right to severance. It's just something that you should give people if under certain circumstances.
There is also the WARN Act, Worker Adjustment Re-Notification Act, which basically provides for certain rights for mass layoffs.
If you close a factory, if you're a business of over 100 and you close a factory of 50 or more people, for any reason for most reasons other than you ran out of money, basically, you go bankrupt, you have to give people 60 days notice that you're closing the factory. If you don't, we actually have a WARN Act case right now. You can get into a lot of trouble.
Okay, so the next, we're moving on to the question from the floor.
Yeah.
The first one, let's see, you are constantly subject to verbal abuse. How can you get evidence in the offenders if the offender is denying since the evidence is oral in nature?
So Chuck talked about this earlier. If other people see it happen, it is helpful if it's somebody you trust and they're willing, see if they're willing to sign a statement that you write down about what happened. If no one is willing to do that, then documenting it in real time, not secretly recording, but writing it down when it happens to you on May, what's today, May 21st, you come in Monday morning and you walk in the front door and this guy screams at you and is abusive to you, write it down and document it, and then take it to human resources and say, he did it again. Maybe you wait, not that I want you to have to sit through it for a week, but if he does it every day at 8 a.m., write down what he says each day. It's a lot harder for them to deny it if you have very specific statements confirming everything he said it to you.
And don't secretly recording, but you can publicly recording, I guess.
If there's no reasonable expectation of privacy,
yeah,
you can record.
You pull your phone out and you show him, hey, I'm recording you, and you say it into the recording, and then he's still abusive to you. Nothing's wrong with that. One thing to watch out though for is if the company has a policy against using your phone that way at work, they may get you into trouble for that part of it. So just be careful with it.
Okay, so the next one is, what suggestions do you have in terms of this is also Evelyn's question. The discrimination often very subtle, and the other party can just say it's miscommunication. So I guess the question is, the comment is not directly targeted on race or gender, but it's very subtle.
Oh,
I think you have to tie it still to some extent to the protected class. So maybe if it's like a coded sort of word or coded phrase, like the people like you, that type of stuff, then yeah, I mean.
For example, you made the Max. You said the Asian, not Asian, the African woman that was commented by purple gel, something like that. Sometimes, sometimes people may say, "Oh, chow mein," or a chinchan or something like that to Asian Americans. So.
Yeah, I mean, write it down because it may feel subtle or too complicated when you hear it, but when you write it down, it's not always. And if they're only saying these things to the Asian American employees who work there, it's not that subtle anymore. And it may feel subtle at first, but if they're saying a lot of these little things over time, it stops being little. So.
Okay, so the next one is, what kind of impact publish a complaint may cause to the plaintiff and defendant? I don't understand this question.
I think I know what they're saying. I've heard this from people before. So a lot of people will come to me and they say, I'm afraid of putting my name on the lawsuit. What's it going to do to my ability to get a job after this? If I understand the question correctly, that's what I understand them to be asking. And by the other side of it, what is the consequence to the company of somebody suing them for this sort of thing? Is that
okay?
That's my understanding of it. Chuck, I've never had a great answer to this question of what people think of somebody who's filed the lawsuit, but you're not supposed to be picked on for that.
Yeah, you're not supposed to be. It's illegal. It's retaliation.
Yeah.
But I'm sure it happens. I've seen employers have like do not hire lists and things like that.
But it is illegal.
Yeah.
From a company perspective, they may take it more seriously because they don't want to be known as the company that discriminates against people. That's a really bad look. People are having a hard time hiring right now. And if people know, don't go work here, these are a bunch of racists, they may be afraid of that. So there is value in keeping your name out. The other thing is under the Human Rights Act, now companies that have a lot of discrimination complaints against them, if they add up and the Department of Human Rights investigates, they can get fined if they have enough of these over time. So there can be consequences to a company for that.
Yeah, they're going to be, generally speaking, these agencies will pay much closer scrutiny to to a company if they have a higher quantity of complaints.
Okay, so I guess this one is a real case. In the school, a student insulted a teacher frequently because the teacher was a Chinese. Since the student hated the Chinese teacher before, the new teacher told the principal about what happened. The leader did not take the right action and caused the child to beat on the teacher finally. But the teacher who got hurt by the student was dismissed.
That's
Wow.
horrible. That's absolutely terrible.
That is definitely a case for you guys.
That's crazy. It's really hard to be a teacher right now. It's always hard to be a teacher. My wife's a teacher. It's really, really hard to be a teacher right now. And if you have racist students like that, that's horrible. It certainly sounds illegal. I'm sure there's a lot of details there, but it certainly sounds illegal.
The company has, whether it's a school or not, the company has a responsibility to basically safeguard its, well, in this case, the teachers.
Yeah.
And if they don't, I mean, that could be also discriminatory if they have a practice of maybe, taking action against or taking action in favor of white teachers as opposed to Chinese teachers.
So this is a hypothetical. A senior minority professor always gets voted out on his majority white colleagues for leadership position for committees, or they use different reasons such as letting junior faculty take position, the reason that he has never used when other white professor apply for similar position. Does this practice amount to disparate treatment under discrimination?
Certainly looks that way to me.
Yeah.
That's exactly the kind of thing you would look for, that they're using excuses with the minority professor that they don't use for white teachers. Yeah, that would be discrimination.
Okay, so the next one, you have your contact information right now on the slide. So just take away. If the company is asking to sign an employment agreement for a green card, such as you should work for 5 years for the company when we sponsor you, is this legal?
That's a really good question. I don't, Chuck, do you know?
Sharon,
yeah, Sharon, you might
you're
know
an immigration attorney, right?
No, this immigration does not allow this, but on the employment law.
It feels like an indentured servitude contract. I don't,
Yes.
I have to be honest, it sounds illegal, but I don't do employment immigration. I'm happy to, Nelly, that's a tough one. It sounds illegal to me, but I don't know that to be a certainty.
I guess what you'd have to look at too is what kind of conditions are encumbered with that. So I mean, if the only condition to this is the green card, that could be more like an at-will thing.
Yeah.
Unless it's being unevenly enforced amongst, between Hispanics and, and, African Americans or Asian Islander Pacifics. So yeah, it depends on how that actually is also implemented and how it impacts against these different classes.
Is this violation of constitutional law, like, make me servant to you, like in 5 years?
It certainly feels that way.
Yeah.
It feels, if money is being withheld or, other benefits of employment are being withheld in light of that. Yeah. I mean, I would say it's probably definitely illegal.
Yeah.
Okay. So, I think.
Oh, at the end.
Oh, okay. So we have the last one. What bonus is optional or guaranteed? Is bonus target guaranteed?
So that's a good question. So my experience, the examples I'll give on this are the discretionary bonus that's not guaranteed. Think like at the holidays at the end of the year, the boss just for the hell of it gives everybody $500 and like a ham or something like that. Like, hey, I just like everybody. I'm going to give everybody some money because I feel like it. That's very different than I'm in sales. I hit a sales target. And once I hit this target, I get this amount of money. So if it's baked in, if I do this, I get this amount of money guaranteed. If it's, hey, I just want to do this for you, not. Right, Chuck, do you have anything else to add there?
It could also be discriminatory if the bonus is being unevenly applied.
Yeah.
So.
Okay, I think that's all for today. Well, we are like 8 minutes after schedule, but Thank
went
you
long.
all so much. We needed this information, and it's this much, debated contents a lot of times too. So thank you everybody here to be here. If you have any more questions, please direct them to Max and Charles here. You have their contact information here. I think I got an anonymous question, so I'm gonna send it to you. Oh, well.
I don't know if I can, I don't know that I'm gonna be able to read that one, Sharon.
Yeah, but this one is a little bit complicated for me to translate now. So I'm gonna send it to you, and then we will make the slide. We will email all the attendees for the slide also. So if you have questions on this one, for example, from anonymous attendee, please email Max and Charles for this one. Okay, well, thank you everybody for attending, and I'll give Max to your daughter.
Thank you so much, and thank you all for listening to us and letting us talk.
Thanks, everybody.
Please don't hesitate to reach out to either of us with any questions. It stops me from having to do actual work, so I'm always happy to talk to people and answer questions.
Thank you, everybody. Have a good night.
Thank you,
Thank you
Sharon.
too.